Employment cases are lawsuits that employees bring against their employers. And these lawsuits can include claims of discrimination, retaliation, wrongful termination, or any number of other employment claims. But what makes a good employment case? Well, there are 3 factors, and you need all 3. And if you have all 3, you have a good employment case. Here are the 3 factors. First, liability. Second, damages. And third, collectibility. Now don't worry, I'm gonna go over each of those factors, so stick around. Now, nothing in this video is legal advice, but if you want legal advice and you think you have a good employment case, feel free to reach out to my firm. I represent workers in lawsuits against their employers. The link to my website is in the description below. The first thing you'll need to have a good employment case is called liability, or another way of saying it is, can you prove your case? When a worker brings an employment case against their employer, the worker has the burden of proving their case. And believe me, your employer is going to make you work hard to prove your case. So even if you know your employer broke the law and did something illegal, if you can't prove your claim, you can't win in court, and you don't have a good case. Let me give you an example. Say for instance, a worker reports to her manager what she believes to be discrimination. The manager doesn't like that the worker just reported discrimination, and the manager holds a grudge against the worker for 2 years, just waiting for an excuse to fire her. And finally, after 2 years, the worker slips up and makes a few mistakes on an assignment, and the manager turns around and terminates the worker. As you know from my other videos, that would be a case of illegal retaliation. The worker engaged in protected activity when she reported discrimination, and the manager fired the worker because of her protected activity. But this case is going to be very difficult to prove because 2 years had passed between the worker reporting the discrimination and the manager firing the worker. And furthermore, the manager had a valid reason to fire the worker because the worker messed up on an assignment. Now, there's probably other ways to prove this hypothetical case, but for the sake of this discussion, let's just say that it's very difficult. And if you can't prove your case, you don't have a good case. The next thing you'll need to have a good case is called damages. If you win your employment case, the defendant employer has to pay you money to compensate you for what you've been through. We refer to this money as your damages, and that's what the court offers as a remedy. So if there's nothing to collect, then there's no point in bringing the case, and you don't have a good case. So let's talk about damages. When an employer subjects a worker to an illegal employment practice, the laws in Washington, along with the laws in most states, allow the worker to collect their damages in the form of lost wages and emotional distress. But sometimes, even when a worker has a really strong legal claim, it's possible that they don't have any lost wages or emotional distress. In those cases, the worker has nothing to collect. Let's use an example. Say a disabled worker starts a new job and asks for a reasonable accommodation. The employer doesn't want to accommodate the disabled worker and fires the worker, but the worker didn't really want to work there anyway, and they found a new job that pays even more immediately after their termination. Well, as you know from my video on disability discrimination, the employer firing the worker for asking for a reasonable accommodation is a clear violation of the law. But since the worker got another job that paid more immediately after termination, there's not really any lost wages there. Now, as for emotional distress, it will depend on the circumstances. But if the worker only worked there for a short period of time and isn't really too upset about being terminated, then the worker's emotional harm is probably not substantial. So without any lost wages or emotional distress, the worker bringing the claim doesn't really have anything to collect, and it's not a good case. The final thing you'll need in order to have a good case is called collectibility. If you have a case with strong liability and quantifiable damages, you also need to be able to collect those damages. But sometimes employers are legitimately insolvent and don't have the money to pay the damages. And other times, employers are just shady and they'll do everything in their power to avoid paying. Either way, if there's no way to collect the damages, then there's no point in going through the litigation process. To illustrate this point, I'll use an example that happened to me. My client had a really strong overtime claim. The defendant employer failed to pay a substantial amount of overtime, but the employer was a small business operated by a single owner. And when we brought the case, the owner dissolved the business and moved out of state to who knows where. Well, even though we had a strong case with substantial damages, we couldn't collect those damages. And it can happen in more legitimate circumstances too, when an employer is actually going out of business and can't afford to pay damages. Now, there are still ways to collect damages if an employer is insolvent or trying to avoid the judgment, but it takes significantly more work and is never certain that you'll actually be able to collect those damages. So the bottom line is, if you can't collect the damages, it's not a good case. So there you go. Now you know what makes a good employment case. You need to have clear liability, quantifiable damages, and the defendant has to be solvent, meaning you can collect those damages. If you think you have a good employment case, feel free to reach out to my firm. The link to my website is in the description below. And if you like this video, hit the like button and subscribe to my channel. I make videos about the laws that protect workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.